The May 9th, 2018 meeting of the Municipal Code Enforcement Board is called to order. Please stand for the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Ladies and gentlemen, the Municipal Code Enforcement Board is charged with conducting hearings to determine whether an alleged violation of the city code has occurred. Decisions made by the quasi-judicial board will be based on evidence and facts presented tonight. Our meetings are conducted in accordance with Robert's Rules of Order, and each case will begin with the city presenting its evidence of the alleged violations. The respondents will then present his or her case. Both parties will have an opportunity to cross-examine all witnesses. The board members may question any witness. Comments by both parties must be relevant to the case. Persons wishing to speak will be given an opportunity to do so by the chair and must address the board from the podium after giving their name and address. Upon request, copies of materials submitted by the staff are available for review. Board members are reminded to obtain permission to speak from the chair, and questions of the city should be directed to the attorney for the city. At this time, I will ask all persons who expect to give testimony tonight to stand and be sworn in by the Deputy City Clerk.
Please raise your right hand. Do you swear or affirm that the testimony or evidence you're about to give or present is the truth, the whole truth, and nothing but the truth?
Kristen, are the cases going to be taken out of order?
Yes.
Okay. I'd like to have the motion to approve the minutes. Has everyone had a chance to read, and any changes? Motion?
Wait,
May change?
no, I'll reference the minutes on other cases later. So I have no
Okay.
discussion at this time on those.
Okay. Motion?
I'll make a motion to approve the minutes.
I'll second it.
Motion by Mr. Lloyd, second by Mr. Newkirk. All in favor?
Aye.
Any nays? No nays. Okay.
If I do have something before we get, is it, if you grant
You
me
want
the
to
proceed-
talk about that other thing?
Two things.
Okay.
Yeah, if the board will grant me some latitude here. I do want to say that the minutes do reflect some tone and tenor that I probably should have better controlled in the last meeting. The text doesn't reflect it, I should say, the tone and tenor. And I do feel that I owe an apology to both Co-Director Tom Baroni and his team, as well as the members of this board and the city attorney. It's difficult, you know. We don't get paid to do this, we do it because we care. And so that sometimes can override our emotions. So I do apologize for anything that if in any way anybody took it personally, it was not intended that way, that tone and tenor.
Okay, thank you.
And then the only other thing I had was on 162, subsection 162-09, section 2, subsection C. The orientation went over section B, 1, 2, and 3 of section 2, but right after that is section C, which says an enforcement board may reduce a fine imposed pursuant to this section. Now, I know there's been some discussion about the city negotiating things outside of that, so that will probably come into play later, and he didn't touch on that during our orientation. So I just want to make sure that, let it be known that it's written there, we just got orientated on 162, but that part was not covered. So, you know, to me, that fine imposed pursuant, there's no or, if, or what. So I probably will ask for interpretation as to why certain actions might have been taken later on.
Okay, thank you, Mr. Lloyd. I do want to take a little opportunity at this point to thank each of you for being here tonight. There's a lot of us, and it's good. I'm really pleased that you gave that extra 30 minutes to come to it for the orientation. With that said, Kristen, where do we want to start?
Okay. We have two people present in the room for hearings. Sorry about that. We have two people present in the room for hearings tonight. The first case would be case number 173320. And then the respondent for an unfinished business case is also here to ask for an extension, and that's case number 180704.
So are we doing the
So we'll
lead?
start with case number 173320 first.
Okay,
Okay, case number 173320, City versus Joyce B. Lindsay for property located at 12802 Telecom Drive. The case is before the board. 12802 Rainforest Street, and the case is before the board based on alleged violation of Section 8102-13K hardware screens duty to maintain. The case will be prosecuted this evening by Officer Buckland. The city has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Steve Buckland with Code Compliance. This case originated proactively back on December 20th of 2017. The initial inspection noted that there was torn pool screens. Some of that may have been from leftover damage from Hurricane Irma that came through. A door hanger was issued with a compliance date of December 28th. I received a call from Ms. Lindsay advising that she was out of town and needed some additional time, so I extended the reinspection date out to January 8th. Returned on January 10th and observed that the screens had not been replaced at that time. On January 19th, I spoke to Ms. Lindsay, who advised she was getting estimates and needed some additional time. Again, pushed it out an additional 30 days from that point and set it up for roughly February 20th of this year. My inspection on February 22nd revealed that there wasn't any change, and a notice of violation was issued with a compliance date of March 15th, 2018. On March 6th, I received a call from Ms. Lindsay advising of the difficulty getting estimates from screen companies. She had some medical issues and then other issues that had impacted her resources. Reinspection date of March 30th was set. On April 3rd, I sent a text to Ms. Lindsay asking for an update, received a response that she was still having difficulty getting a screen company to even respond, and did have an appointment with Riley Screen for the following week. On the 25th, I received a message from her advising that the Riley Screens could not even start the repair to the end of May or possibly early June, and that the repair was very expensive, needed some time to set aside the funding to be able to get it accomplished. At that point, I sent a message back to Ms. Lindsay advising her that we needed to bring it before the board and that it would be up to you if she wanted to continue to extend the time frame on this. At this time, I'd like to submit a photographic evidence of the torn screens.
board will accept.
And as of this morning, the pool screens have still not been replaced and the property remains out of compliance. And I believe we say that Ms. Lindsay was here.
Any questions for Mr. Buckland?
Yes, sir.
So do you have any evidence that a bid has been, a contract or a bid has been prepared for this work?
No, I do not.
Thanks.
Hello, my name is Joyce Lindsay. I'm very nervous.
Address?
12802 Rainforest Street, Temple Terrace, Florida, 33617.
Thank you. Don't be nervous.
Mr. Buckland has explained my case very well. The dates he has, they're right on. I will tell you that I did, after 8 to 10 tries of trying to get screen enclosure done, I finally found somebody to respond to me, and their company name is ARM, Aluminum and Screen Enclosures. Have explained to them the situation that I'm in, and they started work on that today around 11:30 to get this completed according to the code that I'm supposed to abide by. I don't have an explanation as to why this was, the delay was caused by the screen enclosure folks. I have all the names of the people that I contacted, and there was several no-shows that had made appointment with me. There were people that, there was 2 of them that said they could not do it. There was several that did not even call me back. So when ARM contacted me about this, and I asked them why they felt that I was having such a hard time, and they told me that because of Hurricane Irma and people going back up north, that they were overextending, you know, with being busy. That's the only explanation that this gentleman could give me. At any rate, like I say, I want to comply. I love living in this city. Again, they've started work on this to get these repairs done this morning. And I'm hoping that it can be finished here by this next week so that we can have a reinspection done.
So they are working already?
They are. They had told me, like Mr. Buckland said, when I called him and I explained to him the trouble that I was having, they had told me, this company had even said that they were booked up until the end of June. And I explained to them, I even showed them the letter that I had received, and was very surprised when I came home for lunch and saw that the men were out there. You know, so you folks have a very strong reputation of enforcing your rules, apparently, with builders and contractors. But at any rate, that's my story.
Well, thank you. Any questions?
I just, did they give you a time frame in writing on that, or did they just kind of verbally tell you?
No, the 2 men that were there to install the screening were young men that had been sent there by the company. And when I was, like I say, when I was there for lunch, shook their hands and introduced them, they introduced me, or introduced myself, they told me that they were certainly going to get this done as quickly as possible, and that's all they said, you know, is they were. So at least I don't have to wait until the end of June to comply.
Yeah. Well, we appreciate that. Thank you.
Thank you.
You'll be happier for it. So,
Absolutely.
any other questions? Okay. There being no questions, thank you, ma'am.
Thank you.
Look for a motion.
I'll make a motion.
Okay, thank you, Sean.
We'll just get the ball rolling. Based on the testimony of Code Compliance Officer Steve Buckland and Ms. Joyce Lindsay presented to the board at this hearing, and the documentary evidence received by the board, I make a motion that the board find Joyce Lindsay in case number 17-3320 to be guilty of violating section 8-102, subsection 13, subsection K of the city code, and give, do we have the calendars up here? Uh-oh, thanks, there we go. Give her until June 13th to come into compliance with the code section in question. If the property is not brought into compliance by that date, a fine of $25 per day shall begin to accrue on the date following that date and continue to accrue until the date that the violator provides the city with evidence that the property's been brought into compliance.
Motion by Mr. Lloyd, second by Mr. Stats. All in favor?
Aye.
Opposed? No nays. Miss Lindsay? Do you follow what just went on?
Yes, I sure do.
Okay,
Thank you very much.
all right, thank you. Next. We going to the,
Okay, yeah, unfinished business. Case number 180704, City versus Michelle Edelman and Angelo Ferlita for property located at 6110 Liberty Avenue. The expiration of compliance is tonight at midnight. The respondent is in the audience.
would you like to come up and speak? I don't believe you were sworn in yet.
Yes, I was. I was back there.
Okay. I didn't see
You
you.
can't see me on your.
Name and address, please.
Michelle Edelman, 6110 East Liberty Avenue. I just am here to ask for an extension of 2 weeks. The kids have been, and my son have been working really hard. They've got, they had to end up getting, I guess, a different, I don't know, something. And he had to order 2 parts that they were out of stock. He did that yesterday. And the one young man that's been really doing all the work for him works all day also, and so they work on it in the evening. Sunday was kind of a washout for them, I guess, due to the rain. And so I was just here to ask for an extra 2 weeks, if possible.
Okay. Any questions?
Yeah, I have a question. Where's your son? Is he not able to attend the meetings? Tonight?
His name is not on the property, so I didn't tell him to come.
Okay.
That, I guess you can blame me for. They're at the house in the evenings is when they're working on trying to get it all taken care of.
Okay.
So this is the case
Mr.
where they're doing a.
The engine, yeah, that's
rebuild.
in, everything is in. They actually were turning it over last night, and making noise. But they do have some few extra parts before he can actually like pull out of the driveway with it, that they had to order.
And you feel like it'll be done completely in 2 weeks?
Absolutely. If it's not, it's leaving my property. That's not even has to do with y'all. I'm tired of it.
Okay, any other questions? Mr. Lloyd?
Not of her. I was waiting to see if the city had any comments.
Tom Baroni, co-director of Temple Terrace. On Monday afternoon, I received a complaint from the neighbor on Liberty. When Officer Buckman presented this case, he initially told the board that there was a citizen complaint on this. I advised the resident that I requested only 15 days, and she was pretty adamant that it was 30 days. But I told her within 4 days, it'll be, the fine will start on Thursday morning. So I just want to make the board aware that I did receive another complaint from the initial complaint that I received when Officer Buckland presented the case. Just wanted to add that.
Okay.
Thank you.
Any other questions? A motion? Anyone?
Just a point of clarity, if no motion's made, then it stands as is that correct?
That's correct. So, we have no motion to grant 2 weeks. Okay. Ms. Edelman, there is no motion to grant 2-week extension. All right. Thank you. Okay, next.
On to new cases. Case number 173155, City versus Troy M. Eastman for property located at 704 East River Drive. The case is before the board based on alleged violation of Section 8102-14A, fences maintained in good repair. The case will be prosecuted this evening by Officer Jose Silva. The case city has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Jose Silva, Code Compliance Officer. This case originated proactively December 6, 2017. The time my inspection revealed the side yard privacy fences facing the street in disrepair. This time I issued door hangers with a compliance date of December 22nd, 2017. My inspection on January 2nd, 2018 revealed no change, so I issued a notice of violation with a compliance date of January 17, 2018. The home was unoccupied, so I posted notice at the home as well as City Hall. Mail copies both certified and regular mail to the address of the registered owner. On January 5th, 2018, I was contacted by the homeowner, and we discussed a completion date, and he was given to mid-February to complete the repairs. March 21st, 2018, I re-inspected the property and found no change. I contacted the owner again, Mr. Eastman, and who advised me the fence will be repaired for the first week of April. Mr. Eastman currently does not reside in the residence. He resides up in North Florida at another residence because he's with the Florida National Guard. That's why there's been the contact with him. On April 17th, I re-inspected the property again and found no change at the residence. This time, I'd like to submit photographs I took of the property on May 1st, 2018. It's going to show the fence on the north side of the residence in disrepair and on the south side of the residence in disrepair.
Board will accept.
Also, this past Friday, I was contacted by Mr. Eastman's wife. And apparently when Mr. Eastman and I originally spoke, there's been some miscommunication on what actually needed to be repaired. They've gotten several estimates, but it was out of their budget range on what needed to be repaired, so I gave them several options. Basically remove that fencing right there in front of the house. They have no pool in the backyard and so forth. I told them to go ahead and send me an email to tell me, to ask for a deference for 30 days, which I have no problem because he's currently deployed with the National Guard up in Blanding. I have a copy of the email that he sent me, if you would like to see it.
Board will accept.
So I'm asking for a 30 days extension on it for him to get his property into compliance. Problem with the property right now, he has an odd-shaped property, not your normal property. It's bordered by 3 sides. It's like 4 sides are bordering. No one has on record any land survey showing who has what fence belongs to who or any active fence permits. So there's one side of the property that actually has the fence down, and I asked him, just go ahead and remove that part of the fence when he actually repairs the fence in the front or removes it.
Is that, are all of the fences his fences? Or are all the fences the same? 2 questions.
Don't know. The fences around the back of the property are good side facing his property. But looking through all the records that we have, I can't find any surveys from any of the surrounding properties, any fencing permits that show the fencings were put up, or who put the fencing up. The fencing that needs to be repaired in the front is only like 7 panels, more or less, which you don't need a permit for.
Because it's going in the same location.
Yes, sir.
The fence that's down on the side,
It's on the, if you're looking at the house, on the right side. And the house on the right side is being remodeled. It's under construction.
so it's still kind of a front fence.
Excuse me, sir?
It's still kind of a front fence
No, it's the, runs.
going back.
Going back.
Okay. Any other questions?
I missed the part. Is the property vacant?
Yes, sir.
It is vacant. Okay.
Yeah,
Mr. Lloyd?
Sorry, I did a little research and pulled up the section in question before the orientation today. I noticed in section 12-861, it says an application and you stated there has never been one, is he going to be required to submit one to repair the fence?
He's not going to replace, the side fence that's missing sections, he said that's not his.
Okay.
I think from what we heard tonight that we just, not weight that into our deliberation.
Well, no, but he brought up irregular lots, which is part of this now. So,
Well, you wouldn't know that unless you looked it up.
well, I'm on the code board, I should know the code violations.
Is that out of the code
That's
book?
directly from the city of Oliveris.
Okay. All
With the
right.
diagrams, talks about irregular lots and
All right.
exceptions to be made.
Okay,
Three panels or less, you do not need to pull a permit.
Okay.
I got one more for you.
Yes, sir.
He mentioned, you told him that he could remove the fence and the problem, because I noticed in this thing, he said he couldn't get quotes or he only got a couple and stuff like that. Was he open to removing it?
I gave him those options.
Yeah, okay.
So
So he's got,
basically, the miscommunication came where he thought he needed to replace the front
Yep.
and that broken side.
so he could simply remove that section and it goes away?
And I told him, just remove the front
Yep,
and you're good, and you'll be fine.
okay.
And
yes, sir.
question for the city. So you're basically asking for a 30-day extension. So are you looking to find guilt, or is the city attorney looking to pull this case back and bring it back before us in 30 days?
I will say a finding of guilt and bring it
Yeah.
in to compliance in 30 days if it comes into compliance.
You can always come to the board again next month.
Well, I know, but since we had the thing about he testified that he got the letter, he's deployed, and so we were looking for 30 days to pull back. I didn't know, we've had that in the past, the cities have pulled it back because of certain circumstances, and I wanted to make sure, were y'all looking to find a verdict of guilt, or were we looking to pull this back
We're
off?
looking for a finding.
Okay.
Call for a motion.
Thanks. You gonna go?
I'll take it.
All right. Thank you.
Based on the testimony of Code Compliance Officer Jose Silva on case number 17-3155, presented to the board at this hearing, and the documentary evidence received by the board, I make a motion that the board find Troy M. Eastman in case number 17-3155 to be guilty of violating sections 8-102 subsection 14 subsection A of the city code, and give the respondents until June 13th to come into compliance with the code section in question. If the property is not brought into compliance by that date, a fine of $25 per day shall begin to accrue on the day following compliance date, and continue to accrue until the date that the violator provides the city with evidence that the property has been brought into compliance.
I second.
The motion by Mr. Stats, second by Mr. Westfall. All in favor? Aye. Aye. Any opposed? Motion carries.
And Mr. Chairman, if I may, it wasn't presented to us, and the attorney that did do the orientation said we're allowed to go out and get that. That being said.
Well, but it's in the code, so it's
Yeah, well.
proper.
Well, this is the new codified. I still have the old codes. I know the city a few years ago recodified the code, so
Yes.
that's why I had to go out and get this new codified section, because I still have the old code sections.
Yes,
Okay? That's all.
Thank
Just
you.
stating, defining where it came from.
thank you.
Case number 180268, City versus V. Murray LLC for property located at 13304 Telecom Drive. The case is before the board based on alleged violation of Section 14-59, local business tax required. The case will be prosecuted this evening by Officer Steve Buckland. The city has evidence that the notice of violation and notice of hearing were properly served.
Yeah, Steve Buckland with Code Compliance. This case originated back on January 20th, 2018, as directed by Code Director Baroni to verify current local business tax receipts in my area of responsibility. The initial inspection of the online Sunshine Games on January 20th occurred, happened to be on their grand opening. I advised the employee that a local business tax is required, provided the contact information to him. Reinspection date was scheduled for 30 days later. My inspection on February 13th revealed that no action had been taken in an effort to obtain the local business tax receipt. I provided a copy of the worksheet to the owner that lined out all the paperwork that he needed to provide to the city, and advised that I would return in 30 days, knowing that our particular customer service was also very busy with the same issue with all the renewals that they were dealing with. My return inspection on March 14th revealed that no local business tax had been obtained, and that a notice of violation was prepared with a compliance date of March 24th of 2018. Notice was hand-delivered to an employee, Colin Kaiser, that day on March 14th. On May 9th, just earlier today, I spoke to Sarah Sims, who handles those local business tax, and was advised that they have received the application. It is in the process, but has not been paid for. At this time, I'd like to submit photographic evidence of the storefront.
Board will accept.
Like I said, Ms. Sims had advised that they had turned in all the paperwork, but it still has to go through the process to make sure that's all approved, and that still doesn't guarantee that they will show up and actually pay for their local business tax. So at this point, we're not bringing this particular property into compliance as of this time. There was a previous similar case from 2012, case number 12-0079, and in that case resulted in a fine in the amount of $25 per day, with the amount not to exceed the amount allowed by state statute. And our recommendation is to do the same thing as with a $25 per day with a cap of $250.
Thank you. Any questions? Mr. Stats?
So they're in the process of filling out their application, they have not submitted it yet?
No, the application has been submitted, and they have paid the application fee, but they have not paid for the actual local business tax. Once it goes through the whole process where community development has to sign off on it, and also fire safety has to sign off on it, and then they're provided with what the dollar amount, because the dollar amount is different for every business depending on what type of establishment it is.
So, but they've received the totals and,
It has not been through the process yet, so
Okay.
Online Sunshine has not been given the dollar amount of what they need to pay. It
Gotcha.
hasn't been through the complete approval process yet.
okay, thanks.
Any other questions? Mr. Snelling?
I just need some education on that. I'm not familiar with this local business tax. Roughly, how much money are we talking about?
Again,
Ballpark?
it's, depending on the type of business, 'cause it does range quite widely, depending on the type of establishment. In this particular situation, it would be some type of, whatever they have the dollar amount set for a gaming type of establishment. It'd be one fee. If you go into a barber shop, then it's based on how many barbers you have. If you go to one of the wash and dry places, it all depends on how many washing machines you have. So each business is handled a little bit differently, and that's part of what takes, the process, the time length that it needs to get through to get everything signed off on it.
Is it an annual fee, a repeating fee?
That's correct, right. They send out notices, they start sending them out sometime around June, to let the businesses know, hey, you've got your local business tax receipt expires at the end of September. So they're required to renew them each year, and that's where we're trying to assist the city with from our side, is going out, getting with the businesses, double checking to see that they have them. If not, kind of facilitating them, obtaining them.
Yeah, these guys may not have gotten that notice since you said the apparently a new business now, grand opening, so they may not have
Right, new
gotten-
businesses, is their first time out, so sometimes it takes a little bit longer. We've had some other businesses that had been established for a while, that haven't paid. Those happen a little bit quicker because they have all the stuff has already been signed off. They just need to come in and renew their local business tax. So some of them can happen a little quicker than others.
Okay, thank you.
Mr. Lloyd?
I know we want to welcome new business. As part of the process, did we talk to them about signing and the permitting and the sign codes on that? Because I noticed there was a banner. And you stated previous cases as to how we should find, so I'm going to state a previous case as to signs. Have
Right,
you
they're gonna
communicated to
have-
them about the sign
But
ordinance?
I haven't spoken to them about the signs as of yet.
Okay.
It's just initially to start out with just the local business tax and to seeing whether or not if they're going to stay there or not.
Yeah, I don't want to pile on a new business, we want to welcome it, so the last thing is they get the taxes, and then we come back and hit them again with a sign violation, looks like we're picking on them, so, all right. Good, thank you.
Any other questions? Thank you.
Thank you.
A motion, please.
Get the ball rolling here, okay. Based on the testimony of Code Compliance Officer Buckland presented to the board at this hearing and the documentary evidence received by the board, I make a motion that the board find the Murray LLC in case number 18-0268 to be guilty of violating section 14-59 of the city code and to give the respondents until June 13th to come into compliance with the code sections in question. If the property is not brought into compliance by that date, a fine of $25 per day shall begin to accrue on the day following June 13th and continue to accrue until the date that the violator provides the city with evidence that the property has been brought into compliance. And I guess we need to put a cap on that of, I didn't.
$250.
Of $250. Oh, okay.
I'll second.
Wait, is he put part of the motion in the
He's
cap?
putting it, cap. Okay. All in favor? Well, were there any discussion other than that?
I'll let my vote speak for the discussion.
Okay, all in favor?
Aye.
Opposed?
Nay.
One nay. Mr. Lloyd?
The next case is case number 180433, City versus Min Wei Huang, for property located at 5416 Rainbow Drive. The case is before the board based on alleged violation of section 12860, inoperative vehicle, outdoor parts storage. The case will be prosecuted this evening by Officer Jose Silva. The city has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Jose Silva, Code Compliance Officer. This case originated proactively February 8th, 2018. My inspection at the time revealed an inoperative vehicle in the driveway with a flat tire and no tag. The carport was cluttered, and a discarded bedroom mattress was leaning against the vehicle. At the time, I issued door hangers with a compliance date of February 22nd, 2018. My inspection on February 19th revealed no change, so I issued a notice of violation with a compliance date of March 6, 2018. On February 19th, I conducted service at the residence and I served the tenant. On March 7, 2018, I re-inspected the property and found the mattress and the carport clutter cleared and the vehicle now tagged with an expired tag. On April 19, 2018, I re-inspected the property and found no change. This time, I'd like to submit two photographs taken of by me on April 19th. Shows the vehicle in the driveway. Photograph 1 and photograph 2 shows the expired tag on the vehicle.
Board will accept.
As of May 3rd, I re-inspected the property. The property has come into compliance. I'd like to submit an affidavit of compliance.
Board will accept.
The vehicle has been removed from the property. I request a finding of guilt on it.
Any questions? Call for a motion. Thank you, Mr. Silva. Mr. Stats.
Based on the testimony of Code Compliance Officer Jose Silva, presenting case 18-0433, presented to the board at this hearing, and the documentary evidence received by the board, I make a motion the board find Min Wei Huang in case number 18-0433 to be guilty of violating sections 12-860 of the city code, but because the property was brought into compliance before the date of this hearing, no fine shall be assessed.
Second? Any second? Mr. Stelling, second. All in favor? Aye. Opposed? No nays. Motion carried.
The next case Case number 180780, City versus Hamad Safa Murabak, Life Estate, Abrar Hamdan, Banan Hamdan, and unborn child for property located at 10359 Council's Way. The case is before the board based on alleged violation of Section 810213B, exterior walls maintained in good repair. The case will be prosecuted this evening by Officer Doug Allen. The city has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Mr. Chairman and board members. The case originated proactively on March the 1st, 2018. My inspection revealed the exterior wall of the residence to be stained. At this time, I left a door hanger with a compliance date of March 12th, 2018. My inspection on March 13th, 2018 revealed no change. A notice of violation was issued with a compliance date of April 14th, 2018. No one was home, so I posted the notice at the home as well as City Hall. Copies were mailed both certified and regular mail to the address. My inspection on April 16th, 2018 revealed no change. This time, if the board would accept, I would like to submit photographic evidence of the violation taken by me on April 25th, 2018.
Board will accept.
Exhibit 1 shows an exterior stained wall, and Exhibit 2 shows an exterior stained wall. On May the 1st, 2018, I observed that the wall had been cleaned and the site is now in compliance. This time I'd like to submit an affidavit of compliance. The city is looking for a finding only.
Board will accept. Any questions? Thank you, Mr. Allen.
You're welcome, sir.
Call for a motion. Mr. Snelling.
On a roll. All right, based on the testimony of Code Compliance Officer Allen, presented to the board at this hearing, and the documentary evidence received by the board, I make a motion that the board find, I'm gonna struggle with these names, but I'll give it a good shot here. Hamed Safa Mubarak Life Estate, Abrar Hamdan, Banan Hamdan, and unborn child, in case number 18-0780, to be guilty of violating sections 8-102 subsection B, 13 subsection B of the city code, but because the property was brought into compliance before the date of this hearing, no fine shall be assessed.
Do I have a second?
I second.
Second by Mr. Westfall. Any discussion? All in favor? Aye. Motion carried.
Next case, case number 181400, City versus Jessica Montgomery for property located at 12908 Rainforest Street. The case is before the board based on alleged violation of Section 10.3B sanitation grass weeds. The case will be prosecuted this evening by Officer Steve Buckland. The city has evidence that the notice of violation and notice of hearing were properly served.
Good evening, Steve Buckland, Code Compliance. This case originated proactively on April 6th of 2018. The initial inspection noted overgrown conditions throughout the entire yard. The door hanger was issued with a compliance date of April 9th of 2018. My inspection on April 11th revealed no change, and therefore a notice of violation was issued on April 12th with a compliance date of April 20th. I posted the notice at the front door, so no one was home, and then just requested that the city clerks post a copy at City Hall, and then also to have copies mailed, both certified and regular mail, to the listed owner. My inspection on April 24th revealed no change in the overgrown conditions, and at this time I'd like to submit photographic evidence of the violation.
Board will accept.
It just so happens the day after the notice was posted for the hearing, observed that the yard had been mowed and is now in compliance. I'd like to submit an affidavit of compliance this time.
Board will accept.
and the city is looking for a finding only.
Okay. Any questions?
Property occupied, unoccupied?
It's occupied
It is, okay.
by the owner.
Okay. Just didn't know if it was one of those ones that we'll have to keep an eye on because it's unoccupied.
I did have a phone call from her. It was initially the responsibility of the husband that has been now delegated to a lawn care company, from my understanding.
Guilty as charged.
Yeah.
Any other questions? I would like to call for a motion. Thank you, Mr. Buck.
Here we go.
Here we go. Mr. Stats.
Based on the testimony of Code Compliance Officer Steve Buckland, presenting case number 18-1400, presented to the board at this hearing and the documentary evidence received by the board, I make a motion that the board find Jessica Montgomery in case number 18-1400 to be guilty of violating sections 10-3 subsection B of the city code, but because the property was brought into compliance before the date of this hearing, no fine shall be assessed.
Second.
Second by Mr. Lloyd. All in favor? Aye. Opposed? Carried.
Case number 185010, City versus Jafar for property located at 6116 Whiteway Drive. This case has been pulled as it is now in compliance. Case number 185122, City versus Paramajit A. Varma for property located at 12941 Terrace Springs Drive. This case has now been pulled as it is now in compliance.
Exciting. Question, Mr. Lloyd.
Do these violations not fall under the repeat violation sanctions that could be levied against these properties?
Excuse me.
So you're talking about the last two cases that we?
Yeah.
That's a fire department rental issue,
Okay.
and that's under Len Valenti, and I don't know the status of,
Would we ever consider these cases as repeat violators where we would assess like we do with other code violations, where we would assess a predetermined fine because they were repeat violators?
I would think so, within 5 years is considered a repeat violation,
Okay.
so, but.
I just want to check. They're pulled,
That's
but I
fine.
want to,
It's a good question.
moving forward.
Thank you.
Thank you.
Unfinished business. Case number 180048, City versus Octavius Shawan and Riolani M. Green for property located at 217 South River Hills Drive. An affidavit of noncompliance for Section 8-10213B was submitted by Officer Silva dated April 13th, 2018. Case number 173282, City versus Bernard Patrick Joseph Paul Charles Carmel Marie King and Jacqueline King Rooks for property located at 6702 East 113th Avenue. The expiration of compliance is tonight at midnight. Case number 180209, City versus Abdullah Kadir Najadi for property located at 5217 Rainbow Drive. An affidavit of compliance has been submitted by Officer Silva dated today, May 9th, for Section 12860. And that is it for unfinished business. I do have a case not on the agenda, case number 171669, City versus Resi, SFR Sub LLC for property located at 605 West River Drive. An affidavit of compliance for Section 8-10213C was submitted by Director Brony dated April 19th, 2018.
Very good. Thank you.
That last affidavit of compliance, that was the one on West River Drive where the two young ladies came before the board for the roof conditions and electrical issues. So everything is in compliance with that property.
Super. Lien reduction?
Yes.
Good evening, Tom Barone, Code Compliance Director. I will reintroduce this lien reduction petition request in case number 16-0241, 16-2041, and 17-2008. City versus Yusef A.D. Jabari, property location at 104 Mission Hills Avenue. This lien reduction petition was heard at the February 14th and the March 14th, 2018 Code Enforcement Board, and at the April 3rd council meeting, which I presented a recommendation made by the Municipal Code Board to lower the lien from $71,400 to $21,290. I also presented to the City Council staff's recommendation to lower the lien using the 10% of the original lien of $71,400, plus adding the city cost of $1,957.62, totaling $9,097.62. Using the matrix calculator, which is the market value of the lien reduction, was reduced down to $21,290. If we were to use the matrix using property value instead, which this is what the city staff's recommendation to the board, is to lower the lien to $5,719. By using this matrix, this is a case that is only a guideline for the board to use. Mr. Jabari purchased the property back in June of 2016 for, I think it's 2015, let me correct myself, for $123,900. This property has been vacant for more than 10 years. Neighbors and other residents that have driven past this distressed property, it's been an eyesore for way too long. In my final statement, the city staff recommendation is that the code board reduce the lien down to $9,097.62, or the $5,719, which using the matrix for the property value. Thank you, and if you have any questions, I'd be gladly to answer those questions.
And what was the $9,000 number again?
Okay, that was the 10% of the original lien, and then adding $1,957, which was the city cost.
That was 9,000 what?
$9,097.62,
Thank you.
okay?
And the $5,000 one?
That would
was-
be using the matrix with the land value of $40,000. That's what the Hillsborough County Property Appraiser
And-
says the land value is.
And that number was 5,007?
$5,719,
Okay, thank you.
okay?
I couldn't write that fast.
It's okay, sorry.
Can I ask?
Question, Mr.
Yes, sir.
And
Stats?
which number are you saying?
Mr. Snelling?
Oh, sorry, the city's recommending?
Well, I presented to council using the 10% and the city cost.
Right.
And that came out to the 9,000. But if we use the matrix using the market, the
40,000.
land value, that comes out to the 5,700. So either, I'm making two recommendations to the board, either you use the 5,000 or the 9,000.
Okay, so the city doesn't have a preference, you're just saying that's two
It's
options?
just a guideline.
Right,
Just
I got you.
Remember that, it's
Right.
only a guideline,
Yep,
okay?
okay, thanks.
But the 5,719 is based on the property value today.
Well, that's based on the value that I
Well, of
used.
the vacant lot
Yes.
used in the calculator.
Yes, that's based on the day that I prepared that matrix.
Thank you.
What-
Mr. Stats?
Why did the city go back and review after our hearing and make another recommendation?
Well,
Let me just rephrase that.
Okay.
Was there new evidence?
no. There's what the city staff feels as though that, based on the lot being demoed, with the structure being demoed, it's really hard whether you're gonna use the property value or the land value. And we feel as though that we should be using the land value based on the structure not being there on the property.
But the other question I have is, when the codes took place, the structure was there.
That's correct.
So that's what I just want to make sure, because we're kind of crossing
I-
back and forth.
But the fact is that in order to get it into compliance, the walls came down. The entire place was
Yes,
vacated.
the building inspector, Amir Anisi, requested that the structure, made a recommendation to the contractor to knock the structure down.
Mr. Lloyd?
Apologize, maybe you covered this in your testimony, but I don't see any calculations here. I do notice that there is a outstanding lien of 9309. Has that been satisfied, or is it part of the calculation that's part of your 5,000, 9,000 recommendation?
9309 for,
Owed for utility liens existing on the properties dating back to 6/9/2015? Is that part of the calculations for the recommendation? Because I don't have the calculations in
by
front of me.
by the city cost. Let me just look into that.
Okay.
No, sir, that's not, that was not added into the city cost.
Okay, so that was not added, okay, and then are there any outstanding, since that one wasn't, I'm gonna, you opened the door there, I'm gonna walk through it.
Go right ahead.
Are there any other outstanding permit fees, review fees, any outstanding liens that have not been satisfied on this property?
Well, I know that all permits, as of right now, have been approved. I think he inquired about a tree permit to take down in front of the property. But what I understand is all permits have been satisfied.
And the fees have all been paid for those permits?
Yes, yeah. And maybe Mr. Ahmad can elaborate more on the tree permit, but I'm,
No, I'm more worried about the permits for the building, because you're asking us to take into consideration
Right,
land versus
yep.
building. And obviously, if they've submitted plans for review, there's a fee and certain fees that go with those permits. And if they haven't been paid, then might decide, make my decision whether I want to consider it land or building.
Right.
Because if they still have outstanding fees, and clearly they have a $93.09 fee here
Right.
for utilities.
okay.
Mr.
Yes, sir.
Stats?
Are you done?
Yeah, I'm done.
Just because he brought it up, as of this morning, there was, according to city records, the application fees are not paid for that house. I don't know if they paid them today or not, or, I'm just saying according to the city stuff, so.
All I know is he has the plans, he reviewed them, Amir. You know, again, I understand where you're coming from, and you want to know as a panel whether, you know, they're following through with their permits and stuff. But we're really here tonight based on the three cases. And I understand where you're coming from, but the three cases tonight that I'm presenting is really nothing to do with moving forward. Sir, I get it. I know
Yeah,
you,
yeah.
I know you're like that, and I get it.
Yeah.
But again, we need to move forward with this property in the best interest of the city. I think that, and that's my,
All I'm trying to get in is into minutes what the decision would be made and how that decision was made and his testimony to that. So I'm gonna consider it as a building, then I would expect all building fees to be paid. If I'm considering it as land, then I would, regardless of what fees for the building permit. So that's the reason I asked the question.
I understand.
And that's, you're asking us to wait
Mr.
two
Lloyd,
drastic
no,
differences?
I understand. I understand.
Any other questions? Call for a motion?
No,
Oh,
the petitioner has the right to,
It is.
you do have the right to come up and speak.
and I'll stand by.
All right, thank you.
Yes, sir.
Ahmad Qasim,
Address?
100 Whitesboro Circle, Somerset, Kentucky. I have Mr. Yusuf Al-Jabari with me. I want to say a few words. It's very, quick, that way we can be able to go on with it. I mean, I think you heard the case a couple times. Mr. Al-Jafari, he was not, I think, one of the boards, and they think it's the owner they are misunderstanding is the owner who has money and all that. He's not. He's completely different because he was one of his member family who used to go around him and he was present him and he was mislead him. Actually, it's not. Once he have somebody who's legit about this property, he went on, and to this day he's right here. And I think one of the rumor who was saying like he has a Mercedes Benz and he was to go around the property. This guy, he has this vehicle is a 2000, it's a Honda Odyssey or something. I'm not trying to come down here and try to, but he was misled because of he couldn't be able to. And I think you heard actually that the resident before how hard to be able to get to a contractor or somebody can be able to get something done. I'm gonna make that stress a little bit off of you. A little joke I'm gonna say. It was a heaven, and the heaven has a bridge between the hell and the heaven. And they said, we're going to build a bridge between us. Family can be able to visit. So in the hell, they made the half of it. So, and they start holler, what happened? They said, oh, all your contractors on the other side. So I'm not trying to be, here I hope, I enjoy this, and more and more in Florida, but I wanted you to be able to have, I do have, and I do believe him, Harley, about his situation and his things. The property, it's worth about $40,000. I just want you to think about it, as he paid for $128,000 on it, and he basically already lost, beside what all the contractor took from him. Next things, now it's a land. He wants to be able to go and build home for his family. You asked for a blueprint. We got you blueprint. Pay another expense or also another $5,000-6,000. I just want you to understand this thing. By metrics and on what the city goes by, it's the land is $40,000. And if you're gonna look how much they cost, the city, yeah, I know they have some expense for the city about $1,900, and I think if it can be high, he's gonna ask to be able either again to deduct it or to to do something about it, or he can be able to ask to do it on payment. I'm gonna be honest with you, and that's the final things I spoke with him about it, and I hope we can be able to resolve this problem and quick and go on with this case, and that way he can be able to start something in that land and he use it for his kids. Thank you very much.
Okay, I want to ask you one question.
Go ahead.
And this might seem like a weird question,
Go
but
ahead.
when did this property come into compliance? How did this property come into compliance, in your understanding? When,
Since I got in it, probably 2 weeks, it was already compliance.
when the building was completely torn down?
Yes,
Yeah.
it's 2 weeks since I got in it. He was he was working with me because he was lost. He doesn't know what to do with it.
Right.
And a few walls in there, I said, condemned it. Yeah, there is no building in there, there is nothing in there to be able to look or to be able to use. It is useless,
All right.
Any question?
Any questions? Mr. Stats?
And I'm not sure if you'll even know the answer to this. Do we know why that outstanding utility bill was never paid?
I think it's part of it. He does not know it.
Okay, I was just curious, because it's been there for, since 2015
It's
or
part
whatever
of
it is,
it.
so.
That is not part of it. And do you mind if I ask him?
Yeah, no, I was just curious.
Electric bill, why is it, He said, is that is in my name? He doesn't know it. I mean,
Right.
sometimes I want you to understand this, But I'm very sure he's gonna go and comply to quick as he can.
Any other questions?
I have one for Tom.
Mr. Tom? Thank you.
Thank you.
Yes, sir.
Is this the property we had the fence put up around? We asked them to
The
put a
front,
fence
the
up?
front of the property, yes.
Yes, to secure it as a construction site.
Yes, Amir requested that. He obliged within days right after that. He came back this week and also adjusted the front gate. There was a gap there. Yes, he did put chicken wire there, but it's still to prevent a child from entering that area, that construction site.
And I don't have the minutes from these cases in front of me. That was the reason I asked you on that one there. And was this one that the squatters were in at one time on one of these cases we cited them for?
No.
Because it would be relevant if it's
There
part of
was,
the lien reduction.
there was supposedly a person that fell through the roof,
Okay,
and they thought it was potentially a squatter,
okay,
but there's no evidence for that, no.
okay.
Any other questions?
I just want to add one other thing. In the 10 years, there's been no kitchen in this home. There's nobody been living there, and it's been, it's been an eyesore. And there's really, I can't believe he spent $123,000, but that's what he did, so.
This is reminiscent of the Linda property,
Right, yes,
on Linda Avenue, not Linda the person.
right,
Yeah.
203 Linda.
Thank you.
Thank you.
Call for a motion.
Can you just re-clarify what we're considering here?
Well,
Is it 5 or 9, or is it 5?
well, if you want my recommendation,
No, I just want to know what this, to restate, I guess, maybe the city clerk, or come back up and read the minutes there.
I'm presenting two recommendations.
Okay,
Because I presented the council the 9,000, but using the matrix calculator, I presented tonight to the board the 5,700 and, I think it was $19.
okay.
Again, that's only a guideline, and that's just my recommendation.
I forgot to write it down when you said it the first time, so I apologize.
Thank you.
motion, please.
I thought about, excuse me, I thought about this case a lot, and I really believe this person has lost a lot of money through, these transactions. And the property is an eyesore. I would really like to see it moved on. I think we should go with the low number that Officer Baroni came up with. In fact, we can go with an even number as far as I'm concerned. $5,000 would be my recommendation.
You gonna make a motion on that?
Formally, I guess I move that we reduce the lien to $5,000. Is that formal enough? Case, sorry. All right. Well, actually, it's several cases. Case numbers 160241, 16-2041, and 17-2008. I recommend that we reduce the amount of the lien from $71,400 to $5,000.
Do I have a second?
I second.
We have a motion by Mr. Snelling, a second by Mr. Newkirk, and backed up by Mr.
Westfall.
Westfall. All in favor? Oh, discussion, any discussion on this? Okay.
You go first.
I got a couple problems with it. One is, I'm not quite sure why the city and went behind and decided to reassess the case. There was no new evidence submitted to this, and we still don't have clarity whether or not we're going, the fines accrued on the property when the house was still there. Now, we're going back and saying, well, yeah, they tore it down, which got it in compliance, but now we're gonna go based off the assessed value of the land. We're not playing by the typical rules that we should. The case was violated while the house was still standing there. And just for our legal purposes, which we heard tonight, we gotta stick to what we know. And what we know is the house accrued the violations when it was there. Yes, they did fix it by tearing it down, Also, we still got the unpaid utility bills out there. There's just a lot of, there's nothing new that was presented to us tonight to change that decision we've already made. And that's kind of where I'm at.
Mr. Lloyd?
To take a more positive side of the city's approach, 5,000, I understand that, but it was closer to 5719, I think it was. And then you add the 9309, we're looking at 5,812. So, you know, I would probably go more towards the 6,000 if I was to so take a consideration there, but that's your motion, that's the same to the amount. It's a slippery slope. It's a perilous precedence we're setting. And this is something that, you know, can get us in trouble. We've had a lot of people make concessions in this city. We've come back from some financial discourse, and we are definitely setting up perilous precedents with some of these decision-making and vice versa in cases and how we interpret it. And, you know, a lot of our city employees have made concessions on compensation and benefits, and, you know, you start making decisions like this, I'm sure the citizens of the city of Brooksville never saw their police force going away. And it's because you start making decisions that are not financially viable or based in evidence. And we heard no evidence to that today.
Well, I think that we're going off the city staff recommendation, and there's merit to that. They have, when the 9,000 was brought to the city council, it was not accepted because of information that was.
I'm not testifying, right, because we should have that in evidence.
It is in evidence. It's right here in front of everybody. And you could watch the council meeting and see for yourself. So I think that rather than, the situation is that if we go with 21,000, there's not going to be a house there. So do we want a vacant lot with the grass growing, and then he gets a judgment saying that he doesn't mow the grass, so then he's gonna be back before us, and why would he mow the grass? He's just because he owns a lot and he paid too much for it. I think we have a chance to be reasonable here. This doesn't come to us every month. It's not typical. Yes, it's not typical. But I lean to Mr. Lloyd's number more than the 5,000. If you want to go up, go to 5,800. I don't think we need to quibble over cents. But that would be where I stand.
I do want one thing, clarification. The city denied the 9,000 because it was too low or too high?
They didn't take it. They
Okay.
didn't listen to it.
Okay.
Do we know why they didn't listen to it? Or
Because-
just- I didn't see it, so.
Mr. Tom?
They didn't make any decision at all because they felt that you all should be the ones making the decision, and you had not heard the recommendation from Mr. Barone around the $9,000 amount. So it had nothing to do with any kind of evidence or anything else. They just deferred and sent it back to you.
Perfect.
I would like to state, though, I keep hearing about some rule about the value of property, the value of a house. This isn't a rule. There was a matrix created that came up with that as a guideline only. There is no rule. You don't have to consider the value of the property with the house, without the house. You don't have to consider the value at all. What you need to consider mostly is the three things that Mr. Mueller said to you, and that has to do with the violation itself, not value of property. So please, from the city's position, the reason why we're making two different recommendations is we're not relying on value of property here at all. So that's why if you want to stick with the matrix, the one we are recommending is the one based on empty lot. If you don't want to use the matrix, The recommendation was the $9,000, but right now there is a motion on the table, and I heard everybody vote on that, and then suddenly you called for discussion again. That could be very interesting. So I don't know what.
We didn't vote.
We didn't vote.
We didn't vote.
Everybody said aye. You all.
No, I didn't.
So,
We haven't voted on
okay,
this one.
well, I heard a lot of people vote, so I don't know what that's gonna lead to, so.
I have one question just to refresh my memory. I think that was a no motion thing at the council meeting where they had they didn't have a second, or they didn't even have a motion.
I
I
don't-
think it was a silent,
I don't know that they even made a motion.
yeah, I don't think they did. I just wanted to state that. Okay,
Just for the, I wanted to defend my $5,000 number, because it came from the matrix, right? From the $40,000 value of the property, and we've been directed not, the matrix is a guideline, not set in stone. So that's why I said, let's make it $5,000. That's the only reason.
do you want to hold with that? We have a second, so. you can-
I'm gonna stick with that, yep.
Okay,
I'll just say one last thing is, we're all jumbled here on what to do and all this. My recommendation is, kick it back to council, let them make the final decision. Be done with it.
we have to vote on it.
We
and-
voted on it before, nothing new has been entered into this case. And we voted on it before. I just, we're spinning our wheels.
Okay. We're going to call for a vote. All in favor? Aye. Opposed?
Nay.
2 nays. Mr. Lloyd, Mr. Stats. The motion carries $5,000. This recommendation will now be scheduled for a final determination by the city council at the subsequent city council meeting. Director Baroni will attend this meeting to present the request. I encourage you to attend this meeting. This is for Mr.
Who's gone?
As you will be given an opportunity to speak on the matter to the city council. If the council approves the lien reduction petition, you would have 30 days to pay it, or it would revert back to the original lien amount. Thank you. New business. The lien reduction recommendation for 5205 East 131st Avenue for case number 162515 and 17-0869, City versus NCRC Housing Rehab Fund LLC, was approved by the City Council, reducing the liens from $21,600 to $12,483, which has now been paid in the liens released. And then, any questions on that? Okay, thank you. We want to welcome our alternate member, Brian Hubert, who sat on the board for this meeting.
Thank you.
And then, I guess, any other new business?
Is it okay if I address the board for a moment?
It is.
Thank you, Mr. Chair, board members, Andy Ross, City Council. I just wanted to share with you that, as some of you know that have served on the board for a while, the city attorney represents the city of Temple Terrace, not the code board. In years past, we employed and retained the services of a attorney on retainer to represent the code board. We very seldom called upon him, but every once in a while we did, a couple times a year maybe. Well, that attorney retired, and he sent us a letter a while back, said that he was retiring from practice. We have yet to retain the services of an attorney to replace him, as some of you have pointed out. I just wanted to assure you that those efforts are underway. As the council liaison to the code board, I have met with Ms. Cichon and Mr. Stevenson and Mr. Baroni, and there are efforts underway as we speak to retain a replacement attorney to represent the code board. We're in negotiations along those lines now. The orientation or little presentation that you got today was something that we put together because we did not want to wait to get certain information to you along the due process and ex parte communications, those types of things. So the city of Tampa was kind enough to lend us the assistance of their assistant city attorney, Mr. Mueller. So that's how he came to be here tonight, was courtesy of the city of Tampa. So there will, in short order, be an attorney retained to resume the duties that Mr. Morrison furnished for you before. In the meantime, if you have specific questions in the interlude before we have somebody in place, Mr. Chair, please contact me and I will arrange somehow for you to get, if we have to, we'll have the city manager retain an attorney to answer us just a one question or whatever, although we will have something more permanently in place here very soon.
Thank you.
The only thing about the orientation today, I would love to ask them a question because there was, which I asked them another one, but is there a formal process? I mean, I testified that people contacted me in Publix, and what I did immediately was told them to contact code enforcement, and then I called code enforcement and said, hey, I was contacted by these people about this property, and that's when the second round of violations on that property were brought to notice, not the first ones were brought in. Are we supposed to file a document signed, notarized that was done, or is that phone call sufficient enough, or is that something we need to ask an attorney?
No, well, I won't presume to teach the law, but I can echo what I heard him say earlier, was that to report ex parte communications to the city clerk, and she can confer with the city attorney if she thinks further action needs to be taken, but you can never err by reporting it to the city clerk.
Okay.
And allow the city clerk then and then it's exposed and divulged. But
So maybe
the
the clerk instead of the code enforcement director?
Yeah, that's
Okay.
what we've done in the past. And,
Okay.
and the reason that he didn't open this up to questions and back and forth, we weren't trying to cheat you of that. But first of all, he's not your attorney of record. He's over here courtesy of the city of Tampa to provide a presentation. So he can't really hold a workshop with you where it's a back and forth give and take and you can ask about questions because he's not your attorney. So he can't do that. Now, if and when he or somebody else becomes your attorney of record, then there'll be an opportunity, we'll set workshops up so you can have that. But that's the reason that the format was pretty much one-way communication, but it wasn't accidental or trying to be discourteous to you. It's that he made it very clear when we spoke to him and talked to the city of Tampa about him doing this for us. He said, I can't represent your board unless I'm an attorney, I'm not their attorney, so I can't do that. But I can provide a presentation of sorts that anybody can come to a presentation. So that's why there was no, but there will be in the future
Yeah.
opportunities for that.
And I don't have a qualm with that, because we could what if to death.
Yeah.
I've got the whole statute here in a red line, several questions I'll have when we do get the city attorney. So I spent a few hours
Sure.
reading over statute 162, as well as some of the code violations that were brought before us to the board. And we'll continue to do that. I guess I guess this would be to the chair. Should we not review the code sections in violation?
No, that was fine.
Okay, I just want, because I know they talked about research, and I just want to make sure.
You used the word research. You said, I researched this.
Well, I had to, because I've got the old codes. So I had to go find the new codes and research what it was.
That's exactly right, because you have to look it up. You
Yeah.
don't have hard copies. But,
Yeah.
the fact that it's the city ordinance that you were looking up, that sort of brings it into our
Okay.
purview.
Make sure.
Well, just on behalf of the mayor and the rest of the city council and the city attorney and the city manager and all the city staff, I'd just like to say thank you again for your service on this board. I know it's a night out of your life every month, and it's often frustrating and time-consuming, and it's sometimes thankless, I get that. But everybody appreciates what you do, and as frustrating as it is when the council sends stuff back to you, it's really in deference to you that the council doesn't just want to say, well, we'll decide this and leave you So the council places great value on the code board, both on what you do here and on the recommendations that you make. It does not go unnoticed, as frustrating as it is, I understand. And if it's any consolation, we all make about the same amount of money as you. So thank you very much for your service, and with more to come on the attorney.
Did we get any update on the last time the title searches were done? Whether it was quarterly, annually, whatever.
I don't know that title searches were done at all. What we tend to look for is to see whether something is a homestead property or not a homestead property. We can foreclose on a non-homestead property on a lien, but not a homestead property. If you're talking about a title search, generally, the way I view title search is to see whether title has conveyed and that the person who is usually in the context of purchasing is actually purchasing a valid title. So I'm not quite sure what you mean by title search, and to me, that's determining whether it's been conveyed properly over the years and the person really owns what they think they own. I don't know that the city we are bound by what the property appraiser's records show. That's where we go to see who the owner is. We are not running titles here. We don't have anybody to run titles here, and we would have to hire somebody who is experienced in doing that kind of work.
All I was basically asking is, I understand they look to see if they're homesteaded or not, but we have properties hanging out there for 10-plus years. If they have no mortgages, no nothing on it, the city can enforce their liens.
That's right.
And we haven't done that in years. That's why I was
That's-
asking, do we have a process that the city does where we do it annually, or are we supposed to do it? That's what I'm asking.
I believe that under 162, a code enforcement board can request that a lien be foreclosed upon.
Okay.
Mr. Lloyd?
That kind of got me there. So we can request it. Where will we find if there's any lis pendants to where word number 17 in violation, 17 and filing a lien against this property? I mean, if we're number one, then I'm probably going to make a recommendation that we file a lien. But if we're number 17 and there's other lis pendants, is that on the property appraiser site?
They would a lis pendens is generally filed with the clerk of the court, and so we could check the docket and try to do some research with regard to the property to find out if there has been a lis pendens filed on that. If the property's in foreclosure, we do keep track of those, and we have gotten some money from those where there has been excess funds. The property was foreclosed upon, it was sold at auction. Somebody, usually if the bank buys it, there's no extra money. If somebody other than the bank buys it, there can be excess funds. And I think it was either late last year or early this year, we did actually get some money because there were excess funds. It was bought by a third party. Okay. And we do keep track of those.
And would you recommend that maybe we ask these questions to our attorney before we make a recommendation for the city to file a lien? So that he could maybe find out whether we're 17 on the list of lien holders or number one in lien holders?
What are you talking about? We file the lien regardless. It doesn't matter if we're 1 or 100, we do file the lien.
Right.
Foreclosing on the lien is a whole separate
Okay.
matter.
All right.
So,
That's basically, I was trying to figure out what position we're in.
Right.
Because some we could be first, some we could be 17th, as you said. That's what I'm saying, is there a check and balance on that we ever do or not?
we are, whether we're first or 100 in the list of liens, I don't know that we're checking on that. On properties that are in foreclosure, we are keeping track of those. We get notices when the court has ordered that they be sold so that we know what date to watch for. And then once we can watch that, then we can determine how much money was paid for it.
So we don't know, right? Currently, we don't know what position we are on any of them. That's the question. And again,
The foreclosures, yes, we do. We can
Foreclosures,
easily
yes.
determine on the foreclosures.
so, yeah, I'm just saying, so the city doesn't have any place where we do it annually, we don't do anything, so maybe it's something that need to be addressed by council or somebody else.
I'm not aware of that. You would have to ask somebody who's been here a year to know if it's done annually.
Yeah, and again, my frustration is we've got these liens out there that have been dragging and dragging and dragging and dragging. And if the proper tool to get these properties in compliance, off that list is to file a foreclosure on that lien, obviously, I'm not gonna make a recommendation to foreclose on a lien that we're not gonna see, like you just said, there's some that have no money and there's some that have money. So that's where my goal ultimately is to get those things off of there, the 10, 12 years off of there, and get those moved. And, we've bantered many different ways to do that. So that's why I was asking that question, just for a little more clarity.
Is that it? Any more questions? All right. I call for a motion.
Make a motion to adjourn?
Second.
All in favor?
Aye.
We are adjourned.